All rise, please. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice Hand. To my left, Justice Smith. We will be hearing a single case today, and our rules are, as they always are, 15 minutes per side and no rebuttal. We've read the briefs with some care, and we look forward to your arguments. We will hear number 231342, Group Management 0002 LLC versus Young. And we will hear first from Attorney Regan.
Good morning, Your Honor. Good morning, Your Honors. May it please the Court. In the case of Treglia versus McDonald, the Supreme Judicial Court held that where a defendant is subjected to a default judgment in a first case, and then the same plaintiff brings a subsequent case against that defendant is not collaterally estopped from litigating the issues and the elements of the original case.
Is that a case dealing with domestication of a foreign judgment?
No, it does not. That particular case was state default, then was brought up into the bankruptcy situation. The principle is the same. I contend that this calls upon the court to take the judgment of the New York court, give it full faith and credit. You're looking at a default judgment entered in Erie County. Same rules apply. Mr. Young, I suggest at all times, had the right to litigate the issues in the underlying Erie County case.
Which he opted not to do below, or in New York, correct?
I'm sorry, Your Honor?
But which he opted not to do in New York.
He defaulted in New York, absolutely, yes. He made a mistake, he was wrong.
And you tried to remove the default? None of that stuff is in the appendix. Not that it's necessarily relevant, really, but
Right, no,
you tried to remove the default?
He did, Your Honor.
What grounds did you try?
Our grounds, I think they raised the question of adequacy of service, and the New York court denied that motion. So
Only adequacy of service, that's the whole basis for removing the default.
that was the only basis. I actually engaged an associate in New York. We also pointed out substantial arguments on the merits, including the factual dispute about contract formation. But our situation today is we've got a default judgment. It has not been disturbed. And I suggest the question for this court is what effect to give that default judgment under all of these circumstances. It's not a final judgment. The issues have not been litigated.
It is a final judgment.
Pardon me? Yes, it's final. The issues have not been litigated. And as a default, it has a different standing than a judgment.
I don't see a single case from any jurisdiction saying a default judgment isn't to be given full faith and credit by a sister state. I just have never seen a case like that, and I have seen cases that mention default judgments being enforced.
Your Honor, I'm not arguing that it's not entitled to full faith and credit. I'm suggesting that what that means in this case is how Massachusetts law treats a default as opposed to a judgment in which all the issues have been fully litigated. And the Treglia case says that.
But we have cases saying if a decision is wrong in another state, we don't care. We enforce it. You don't get to relitigate anything about the judgment. Why is a default judgment any different?
Because nothing was litigated. There was no rulings of law, there were no findings of fact. It was a default. And under Treglia...
Can I ask you about the damages?
Yes.
They said $43,000 in damages, and then it's plus attorney's fees, right?
Yes, Your Honor.
Do you know what that $43,000 represents?
I believe it's primarily, well, if I remember correctly, this started with Mr. Young bringing a complaint to the Attorney General.
Yeah.
The Attorney General took up that complaint, and I believe he imposed some sanctions and restitution, and I presume that that $43,000 also includes attorney's fees in connection with that complaint.
That complaint was defended by IPA in Massachusetts.
I believe it was, yes, Your Honor. It was IPA dealt with it in Massachusetts, and the Attorney General imposed the sanctions that they did.
What was the restitution ordered?
I think that Mr. Young received a few $1,000s in additional compensation.
Okay.
Your Honor, again, the thrust of our argument is that Treglia stands for the proposition that Mr. Young had the right and has the right to litigate the elements of both the underlying case and the Norfolk County case.
What case says in the context of an action to domesticate a judgment that any party has the opportunity to attack the underlying judgment from another state?
Treglia takes the concept of a default judgment and interprets what a default judgment means, and permits, and it does not provide for collateral estoppel with respect to the underlying issues in the case in which the default occurred.
But doesn't collateral estoppel require that the effort be to relitigate the facts that were determined in the first action?
Well, it's not relitigate because they never were litigated.
Okay, but the point of it is that. But the action to domesticate a judgment is not seeking to determine whether those facts were right or wrong. It was seeking to
this is not merely
here.
an action to domesticate a judgment, Your Honor. If you look at the entire scope of the complaint, it realleges all of the same facts.
Oh, look, you say that in the brief. The counts are enforce the judgment and reach and apply. It's not a contract case. It's not. It says it describes the underlying facts, but they aren't alleging breach of contract, right? They're alleging we have a valid judgment in another state, please enforce it, right?
That certainly is the addendum in the complaint. Yes, Your Honor. But again, characterizing this simply as an action to an action to domesticate the judgment does not eliminate the consideration of how Massachusetts law treats a default, as opposed to a judgment in which all issues have been litigated.
Do you think the damages amount is collusive?
I believe there's certainly a possibility. We've had no discovery, but it seemed as though GM2 and IPA had an interesting business relationship, and they just got together after the default and said, here's the numbers we want to work with. I can't tell you about the insides of it. It's a worthy suspicion.
Was there any further... Is the only thing the defendant, Mr. Young, received from the court or from opposing counsel in the underlying New York action service of the, whatever they use there, summons and complaint, or...
Third-party complaint by GM2, yes, Your Honor.
And so after the liability portion of the proceedings, before the damages part, was he informed in any way about that, or that's just something that appeared on the docket, and if he'd had a lawyer, someone would have known?
Off the top of my head, Your Honor, I do not recall if he had separate notice of the judgment having entered or a separate notice of damage assessment.
And he had no counsel at that time either?
He had no counsel. He was the reason for his error in this regard, Your Honor, was, again, he's a layman. He didn't appreciate the hazards of a default. And he was under the misimpression that having resolved things with the Massachusetts Attorney General, that's it, there's nothing else to take care of here. So that's my understanding of his thinking at the time that he did not respond to the third-party complaint. But again, one of the points I was going to make is that this case fits as a good parallel to the Treglia case, in which you have underlying action results in a judgment. Then the same plaintiff brings a subsequent action.
Well, this isn't exactly that. Now, can I ask you, I don't know if it's a matter of record, it's probably public record, what has happened with there are two, there's a Norfolk and a Suffolk.
The Suffolk case, Your Honor, is being held in abeyance pending the outcome of this appeal.
And that is a declaratory judgment action, or what have you saw?
It's a declaratory judgment action, which is designed simply to identify issues that have not been adjudicated either in the Norfolk action or that wouldn't be adjudicated by this court with respect to the appeal.
See, the problem I'm having with your argument, well, maybe it's clear already. If there were no personal jurisdiction, we wouldn't enforce an out-of-state judgment.
Understand,
right?
Your Honor.
That's clear, but that's not what you're arguing.
That's not the argument, Your Honor.
Okay, and if there were a collusive or fraudulent judgment, which I have to think about, this case is suggesting we wouldn't enforce that. But the fact that it's not res judicata, as I understand it, doesn't mean that the judgment is ephemeral or non-existent.
I don't say that it is, Your Honor.
It means that if there's another suit, it's decided for this suit. So, for example, if your client lived in New York and they had this default judgment, they just go collect on it. Like, I don't know what the execution process is in New York, right? But they just do that. But if another case came up and the question was, well, you know, was there a breach of this contract, you'd still have all your arguments available to you.
And that, well, that is the case here, because although it's not the count, the relief sought, the allegations of the complaint raise all of the same factual issues. And the complaint relies upon all of those facts as part of its wherefore for the relief.
Do you know if GM, whatever this is, whatever it's called, GM 0002 LLC, has any clients other than IPA?
I don't have that information, Your Honor. Again, this case never reached the point of discovery.
Okay.
So I don't know that answer. But, Your Honor, I'd like to focus the court's attention on one of the first and most obvious elements in this case, and that is it's the question of a SLAPP suit against public participation. It's explicit in both complaints that the complaint here is you went to the Mass Attorney General's and we made you sign a contract that said you wouldn't do that. We are now retaliating against you in this lawsuit and punishing you for it.
If we disagree with you that that's one of the claims that's made in this action, does the SLAPP suit argument stand up?
I'm sorry, what's not in this action?
If we view the claims here more narrowly than you do and see them only as seeking to reach and apply and to enforce the judgment, does your anti-SLAPP argument still
I would suggest that it does, Your Honor, because under Bristol, you do a de novo review of the denial of a SLAPP motion. That requires you to take into account the totality of the circumstances and the fact that both at combining Treglia and Bristol, Young has the right to litigate all of the elements of the underlying case in the second case. In analyzing that, you have to observe that both cases are SLAPP subject. And I would suggest that the de novo review requires you to embrace both actions and recognize what they really are. The two actions are of a piece. Let's retaliate against Mr. Young. And this court can and should recognize that and grant a slap motion. I would also point out again, the factual disputes highlighted in the summary judgment materials. And I also would, I'm almost out of time, I also would emphasize the nature of the contract as being against public policy. I strongly suggest that although it's styled as an enforcement action, it is done with the complete body of factual allegations, and his request for relief relies upon all of those same allegations. So I would respectfully submit, Your Honor, that the court should reverse the slap rulings and the summary judgment ruling, and I'd ask you to do so.
Counsel, is your argument that a default shouldn't trigger res judicata, that the complaint should still be reached on the merits, is that stronger in Massachusetts than it would be in New York?
Your Honor, just, is it stronger? Well,
there was a motion to vacate the default judgment. That was rejected. There was a hearing. And
that was rejected. But again, this issue was not raised. My understanding is that the full faith and credit requires this court to give the same effect to the default judgment that New York would have done. And it's not in my brief, but I have a case I'd offer to the court of Rojas versus Romanov in New York. And it also stands for the proposition that a default does not collaterally estop a later challenge.
What is the citation?
If I may, I'd offer you a copy, Your Honor.
No, you just tell me the citation. We can look it up.
Absolutely, Your Honor. It is July 2023. I apologize, I'm being slow here and finding the citation. On this print, I don't know if I see the citation.
Well, you know what, if you want to, on the way out, if it's just a copy of the
I'll
case,
offer it up to the-
and if your brother has a copy,
Certainly.
you can give it to the court officer and...
Of course, Your Honor. But my understanding, Your Honor, is that, is it stronger or weaker? Either court, well, if you take the position that the judgment cannot be looked into, as I suggest it should be with Treglia, then I don't know if it's stronger or weaker. New York has the same principle of not imposing collateral estoppel on a case such as this. In New York, he could have just moved to execute there if he wanted to. There's a whole alternative way that that GM2 could try to execute is using the statute. But he saw fit to bring a separate action, which raises all these issues.
Okay, your time has expired, so unless I see further questions,
Thank you, Your Honor.
very much for your argument. We will hear next from Attorney Garabedian.
Good morning, Your Honors. May it please the Court, Stephen Garabedian, representing the appellee plaintiff, Group Management 2, LLC, referred to as GM2. GM2 looks at this case as a judgment collection case. It's about money. It's about the collecting of money. It's not about public policy arguments. It's not about an anti-SLAPP. This isn't a SLAPP suit. The SJC has identified what the components of a SLAPP suit are. It's a lawsuit that's brought not to win, but to chill the opponent's exercise of their constitutional rights. That's not what is happening here. This is a valid method to collect a foreign judgment that entered in New York, where Mr. Young had the full and fair opportunity to appear, defend, and consciously chose not to appeal the denial of his motion to vacate which is one of the aspects of this case that it's strategy. The strategy that Mr. Young has taken has tied his hands in Massachusetts. I know there's talk about whether the merits of the underlying suit were all argued. I would suggest to the court, the record appendix does contain the materials that were submitted in support of the motion to vacate in New York, and that's in the record appendix, pages 37 to 53. It's the motion, an affirmation, and Mr. Young's affidavit. And that outlines...
What's the standard for lifting a default in New York, do you know?
It's cited in the rule in my brief. It's the same as here. Excusable neglect, you have to demonstrate one of the various reasons, and, lack of service would be one of them. Jurisdiction hasn't been argued by the defendant.
No, I agree with that.
In this case, and I think that's what tied the trial court's hands, and I think that the judge understood that. That's why the case was stayed, and Mr. Young was given an opportunity to go back to New York and attempt to vacate this judgment. He sought the relief in New York, appeared through counsel, thereby submitting to their jurisdiction again.
Well, again, I don't know what that means. At the time of the judgment, I don't know if he'd submitted to their jurisdiction or not. I don't know that someone coming in after the fact to try to lift the default retroactively gives him a presence in New York.
Under their rules, it does. If they do not request dismissal of the case on jurisdictional grounds, they have then submitted to the jurisdiction of the court. It's like a nuance in their rule that requires them to both appear, argue, and request for their relief dismissal. And instead, in their motion, they request an opportunity to be heard on the merits.
If I conclude that your contract is void in Massachusetts, does that change anything?
Well, I don't think it changes anything as it relates to the money judgment. That's a separate finding that's entitled to the full faith and credit. If you're saying the contract is void, I would argue that it's not void in its entirety because it's an operating agreement. There could be voidable portions of it.
Not voidable, void.
Completely, if the contract was completely void under Massachusetts law, I still don't think it matters because the terms of the contract are to be the contract is to be construed in accordance with New York law, and any challenge to that contract.
Do you know if New York has a statute like we do that makes it impermissible for an employer to attempt to contract out of Wage Act protections? I did
not brief that issue. I don't know offhand.
We do have a statute that says that.
I'm aware that in Massachusetts that is a statute, but in this case, GM2 is not an employer, and they were never.
I have no idea if they were an employer or not. Apparently, Ms. Young won something here before the Attorney General.
Like it's a third party, not us. Not GM2.
Yeah, but they're a third-party defendant in that person's suit against you. Right, this money is the money, presumably, that you owe IPA
yes.
because of the success of Mr. Young's AG action here. But it doesn't matter. I don't know whether he's an employee or not. But you can't punish him for bringing a claim under the Wage Act in Massachusetts under contract. And it does say in the contract, in the operating agreement, it says one of the main purposes of this is to make sure that no one will be treated as an employee who is, a member or whatever it's called.
Yeah. Well, yes, it's because I would kind of push back on the point about him being a layperson. He's a layperson to the extent of the law, because he's not a lawyer, but he's a sophisticated individual. He audits complex insurance policies. He understands terms of insurance.
I mean, he's passed away.
And in terms of the avoidability, whether the contract is void here, whether that affects, I don't think it affects the money judgment, and I don't think it affects any award that was granted in the trial court, because the contract itself is the validity of that contract was was determined in New York, because if the contract...
It's illegal in Massachusetts, this contract, in my view. It's an illegal contract, I think, in Massachusetts. I think it violates that statute.
Well, I would suggest that if it was an illegal contract in New York...
I don't care about that. You're in a Massachusetts court. I just asked. It may make no difference. I understand that.
Right.
Because there is a judgment in New York. But I'm just asking, if it's a completely void contract or unlawful, does that change anything, or we just give full faith and credit?
I would say it wouldn't change anything under these facts, because that was not argued in the attempt to reopen the litigation there. It was never argued, so in essence, it's waived. And just like many of the other claims that have been made in the Norfolk action and here on appeal are waived or have been determined. I don't think there was, and the reason why I think it's more straightforward than it's being presented is because there's been no legitimate challenge to the money judgment itself. The jurisdiction questions have not been raised. The note, I know Your Honor had asked about Mr. Young's receiving of notices. There are 4 notices that were sent registered mail. That was the service of the summons and complaint, the request for the default judgment, the notice of hearing on the default judgment, and then the notice of entry of default judgment. That is set forth in the summary judgment record, my client's affidavit, and that's in the appendix as well, and it's on page 51 of the appendix. And I would note that there were exhibits to that affidavit that showed all the receipts and the tracking information for each one of those, but those aren't included in the record for whatever reason.
Do you know if GM2 has any clients other than IPA?
I'm not sure. I don't know exactly. I assume they do, because I don't think IPA is operating anymore. So I assume they do, but I'm not sure, and I don't want to misrepresent something that I'm not.
No, that's
sure
fair. It's not in the record. It's not in the record.
So again, I think in terms of the anti-SLAPP, I think it could be disposed of because of the independent basis, which we've gone over. The summary judgment was properly entered because, again, the trial judge understood that his hands were tied on this. He has to, Massachusetts is required to recognize and enforce the judgment. And all of these attempts could have been made in New York. I think all of these arguments would have been better.
Or maybe yes, of course they could have, of course. I don't, maybe they have no basis for lifting the default. That may be why they didn't appeal, because they got nothing, or they've got adequacy of service, but really it was adequate.
But I would suggest to the court that Mr. Young could easily have filed a declaratory judgment action to declare provisions void. And if obtained a judgment there, it could be then used to attack
You don't think that the judgment there is res judicata to that?
Well, I think the law in New York as well as in Massachusetts, it's not determinative of all issues of the case. It's determinative of certain issues, and in that case, in New York, it's the amount that's owed is a determinative fact in the case. Is if there's another basis to declare the contract void, he's able to assert that in New York per the terms of the agreement. He has the ability to file.
He could go, or his estate could go now and file a declaratory judgment action in New York?
Probably too late because it's past the statute. I would assume it's past the statute of limitations in New York. I'm not sure. It could be an 8-year statute, but if it
Doesn't it seem to you that would have to be a counterclaim in your suit?
That's another
rather than
issue.
Just a freestanding post-judgment?
I would agree. I would say that, yeah, it would have been better served as a counterclaim. There was no answer filed in the Norfolk
No, I
action.
understand that.
And so that's kind of what we're left with. And at the end, I think that the core issue is straightforward. I do think it's a full faith and credit issue, and I think we understand that. I don't want to keep going over it. But the SLAPP statute was not intended to prevent a judgment debtor from paying a legally ordered judgment. That's not what it's intended for. It was to protect him and his rights. And if he wanted to assert that, he could have. There is a SLAPP statute in New York, as in many states, and that could have been asserted there. I don't think that was argued in their motion to vacate, but it probably should have been. And I don't want to go. I don't think there's anything else really
Also, what do you say to your brother's argument that Treglia prevents us from awarding, or Massachusetts from awarding the judgment or giving preclusive effect because the merits weren't reached in New York?
Well, I think again, that case is dealing with in-state judgments. It's not an out-of-state judgment, so.
You think the full faith and credit take it outside of Treglia's ambit, essentially?
Well, in terms of the amount of money that's owed, absolutely, because.
No, in terms of whether the claims were litigated and whether he has a right to litigate the claims.
Well, I would argue that the claims that he's asserting here were litigated in the sense because he sought relief from the judgment and argued these points. If
They sought to vacate the default, right?
Yeah, and that's a request for relief from judgment. And so if.
But the issues weren't reached on their merits. We don't know whether or not they were, and they likely weren't on a motion to remove the defaults.
Well, I guess in terms of the only issue that would be left open for if that, in the Treglia case, the only issue that I guess wouldn't have been fully determined is liability for attorney's fees. Because I don't think there's anything else that Massachusetts would look at in that contract to say that there's other claims that need to be litigated, because there's no other claims that have been asserted. It's just, this action is the collection and then seeking the additional attorney's fees under the contract, which, again, the provision itself includes the cost of collection, which I would argue that that's what this entire case is all about. So I don't think it really has a bearing on the prime issues that are before the court. I had thought about this case in a sense of how it would have been handled if this was a Massachusetts judgment. If we look at it as a Massachusetts judgment where a creditor files suit and obtains a judgment by default after notice, and the defendant comes in and tries to vacate that judgment unsuccessfully, doesn't appeal, and then that creditor then files a subsequent lawsuit, none of these defenses are available to them. They can't assert the anti-SLAPP at that point because they had the opportunity to do it in the first case. They didn't do it within the 60 days. I would argue that that would be waived. And then any of these other issues they had the opportunity to do that and appeal and assert those arguments, and they didn't do it. So if we look at it in the in-state context, it's essentially the same as this out-of-state context because we're not reaching the arguments about the validity of the judgment. So it's entitled to recognition here. So we kind of start at that point if we can look at it the same way. So I would say that arguably, because the case of the Robbins v. Kroc about the recovery of the fees in a suit on judgment, they would be available in the same context if this was an in-state judgment, if a suit on filing a suit on the in-state judgment. And I don't have anything else. And
seeing no further questions, thank you very much for your argument as well.
thank you.
Both were very helpful to us, and the case is submitted. That concludes our sitting for today. I'd like to thank the court officer. You can just hand it to the court officer. I'd like to thank the court officer for his assistance. I'd like to thank the court staff for their assistance. And we stand in recess.
Well, all right, please.